Harry here to talk about a Supreme Court argument and case that portends a very significant and very problematic decision by the U.S. Supreme Court, essentially negating the one remaining provision of the Voting Rights Act that still has real force. That is Section 2. I'll get into it in a moment, but of the 60 or so African Americans in Congress, 15 or so are in so-called majority minority districts that were drawn in gerrymanders in order to approximate the relative percentage of African American voting in the state. So Louisiana, which is where this case comes up from, is about 1/3 African American. It first drew a map under Republican control where there was only one district that was majority Black, and so it, in that sense, might well have produced an underrepresented contingent in Congress. That map then had a very elaborate, convoluted history that I think doesn't matter so much now, but its constitutionality and lawfulness went up and down twice to the U.S. Supreme Court, which most recently didn't even decide it and rather set for another argument, the one that was just had yesterday, about the constitutionality of Section 2. So it really was a bit of a thunderbolt showing that Section 2 itself was potentially on the chopping block. Okay, let's talk about Section 2. Let's first talk about the Voting Rights Act. Passed in the mid-60s, considered by many the most important civil rights legislation in the nation's history. Great Society under Johnson, remedying the long-standing wrongs against African Americans, including after the Civil War amendments, when so many states, especially in the South, imposed all these hurdles and strategies to continue to dilute their vote. That was going on in really dramatic fashion up to the Voting Rights Act. And the Voting Rights Act passed. It has 5 sections, but 2 are the ones that really matter. The most important was a section called Section 5. And in that section, Congress found that there were a whole cadre of states that had engaged in these discriminatory techniques and efforts for years and years. And going forward, if they wanted to make any changes to their voting processes, like times of voting or the like, they were going to have to get pre-clearance from, and it turned out, a sort of section of the Civil Rights Division in Washington. So they couldn't just, so many of the stratagems that had diluted the vote sounded neutral on their face, or not, reading tests or all kinds of nasty maneuvers. And Section 5 said, if you're any of these states with that history and you do any kinds of changes, we've got to pre-clear it. And many, many efforts to mess with voting procedures, often for certainly mixed reasons or reasons that had a lot to do with politics. Just the Republicans wanted more power, had to go up, or Democrats, but this is typically a Republican dynamic of diluting African American votes, would go up to Washington and come back not approved. Then, in a really important case a few years ago that you may well remember, the Supreme Court, by John Roberts, just basically said, we're not going to do this anymore. We've just decided the way to cure racial discrimination is to stop discriminating by race. And it's been long enough. Section 5 is null and void unless and until Congress reenacts it. Now, Congress had been renewing it every 6-7 years in lockstep. They had done so here, but by fiat, the Supreme Court says we've gone long enough. So we actually still have a Section 5. but it's a dead letter. It says all these states must do pre-clearance, and there are 0 states in there. Okay, so all focus since then has been on Section 2. And Section 2 says that if you draw a map that actually discriminates against African American voters, that's a violation in and of itself under Section 2, and you got to go back to the drawing board, which is what happened in Louisiana. The state initially drew that map. Only 1 out of 6 seats were majority-minority, likely to result in the election of a Black member of Congress. And the district court and then the Fifth Circuit said, well, again, after back and forth with the Supreme Court that didn't disturb it, said, you've got to redraw a map. They did. And it's the redrawn map that was effective in the last election and had a second African-American congressman elected that now went up to the Supreme Court. But before it did, the court introduced a new question. Is Section 2 constitutional in the first place? Because, and the suggestion first coming from Justice Thomas, the Voting Rights Act is passed under the 15th Amendment guaranteeing election, and that's supposed to get at intentional discrimination. So this effects test, which is what the second section of the Voting Rights Act puts into play, that is, you drew something maybe without having racial animus in mind, but it turned out that to really disenfranchise Black votes must be redrawn. That's Section 2. Okay, sets us up for the Supreme Court argument yesterday. And it was pretty darn clear that the majority is fixing to strike down Section 2. Thomas, among others, I think will assert that there are different kinds of arguments there. Thomas, for example, seems to think it's just a violation of equal protection to ever do this based on effects. The real sort of focus of the argument, though, came from a couple questions by especially Justice Kavanaugh. And his idea was, well, hey, haven't we really said, and they're pointing both to the Section 5 case, also to the affirmative action cases, it may be okay to do race-based remedies, but they have to be time-bound. We just can't go on forever. There's got to be, a boundary. Now, you can see that argument. Of course, if it exists, who should set the time boundary? It seems evident that that's something for Congress, not for the court. In the Shelby v. Holder, the previous case where they struck down Section 5, Roberts just sort of said, ipsa dixit, that's law speak for just cause, 25 years, that's about enough, and we're done. So they drew, with no real basis at all, in a kind of arbitrary way, the timeline. And Kavanaugh, I think, is really suggesting that they'll do the same here. They'll just say Section 2 was there. We're not overruling it exactly, or maybe, but we're definitely gutting it because it's been long enough. Again, a completely sort of legislative judgment. Moreover, as at least one question from Justice Jackson seemed to suggest, and I should say here that all three of the progressives, Jackson, Sotomayor, and Kagan, were obviously, distraught at the notion that what we all grew up thinking was the banner hallmark civil rights legislation is maybe about to hit the dustbin of history. But look, what Section 2 says is if you draw something that discriminates against African Americans, go and try it again. And what's that got to do with if they do it 50 years from now, but not before? That's the violation that arises then. This isn't about, unlike Section 5, which has that presumption against certain states. This isn't about remedying old problems. This is today if you discriminate. And in the mindset of many, there are maps that, of course, do get drawn in such a way as to dilute Black votes. But, and this was the submission of Louisiana, it's not about race, it's about politics. African American voters are more likely to vote for Democrats. If you're Republicans in control of the process, you want to have fewer districts where African Americans control, because they're going to be more likely to elect a Democratic representative. So another focus of the argument, I would say there is two. There's the sort of outlying Thomas, it's all unconstitutional. Then there's the Kavanaugh position of, well, it's got a sunset, and we, the Supreme Court, why not? We'll say when it does. And then the third big idea here is, if we're doing it for political reasons to favor Republicans, that's not the same. Now, that would be a radical overhauling of Section 2, because Section 2 says if the effect is to dilute the votes of African Americans, then it violates Section 2. But the court, I think, could be pointing toward the rationale saying, but if you're doing it for politics, or it's sort of even Steven, that's not a Section 2 violation, which would, in other words, would be a vast narrowing of the scope of Section 2. Section 2 now is about effects. If you happen, for whatever reason, to disenfranchise African Americans, you gotta change that. Now the court is pointing toward a decision where, but if you're doing it for political reasons, oh, that's okay. So the way they would put it, again, this is, we'll have to see how the opinion really writes and comes out, but it's something like Section 2, we're not striking down. We're simply saying that if it's politics, then that's not the effect test under that makes for a Section 2 violation. Of course, that's like an inherent contradiction, right? The effect is to disenfranchise African Americans, but the section that says you can't have that effect doesn't apply. So, summary. 6 members of the Supreme Court seem absolutely bound and focused on gutting. I think they won't necessarily say we overrule Section 2. After all, they didn't say it on Section 5. They just made it completely without practical effect. They'll say something like that. The progressives will really protest mightily. And the kind of, shining star civil rights legislation that has been a part of the history of this country of remedying and trying to make good on a history of real discrimination against African American voters is basically going to be wiped from the books at by the U.S. Supreme Court. That's very much how things were trending after yesterday's argument. This is the kind of case that will take many months to actually come out. And as I say, I don't think they'll exactly announce that Section 2 is overruled, but the effect will be that the robust, powerful Voting Rights Act is now less than a shadow of its former self. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.